A warm welcome to all the participants, Dean Sir, and our guest speaker for this workshop. It is my pleasure to introduce Dr. Purnima Chandran, a registered Indian patent agent and a distinguished techno-legal professional in the field of intellectual property. Currently, she is working as a DPIIT-IPR chair professor at Maharashtra National Law University, Nagpur. Dr. Chandran holds a PhD in reproductive biology from Jadavpur University and an LLB from Osmania University, bringing together strong expertise in both life sciences and law. She has held several key positions in the IP and pharmaceutical industry, including Patent Manager at Enveda Therapeutics and Deputy Manager IP at Curatech Biologics, a part of the Aurobindo Pharma Group, along with senior roles at IP Niti, Prometheus Patent Services and Clairvolex. Her work has extensively focused on patent drafting, prosecution, patentability analysis and global patent strategy, particularly in biotechnology and pharmaceutical technologies. She has handled the complete patent lifecycle from invention, harvesting and drafting to prosecution and hearings before the Indian Patent Office. Dr. Chandran is also an advocate enrolled with the Telangana State Bar Council, a registered trademark agent and a Fulbright Nehru Doctoral and Professional Research Fellow. Please join me in warmly welcoming Dr. Purnima Chandran. I now request Professor Alok Das Sir to felicitate our speaker, Dr. Chandran. I now request Dr. Chandran to please take over the mic and start the workshop.
Thank you so much, the host institute, IIT-ISM Dhanbad, for giving me this opportunity, and also the DPIIT-IPR chair, department, Dean Sir, and all the relevant stakeholders for giving me this opportunity to share whatever little knowledge I have about patent drafting and prosecution. So without further ado, I would just like to start my presentation. So I start with one of the first things is it's just whatever we are discussing in this workshop is a part of an academic pursuit, and none of this can be construed as a legal opinion. So I'm sure everyone in this audience know what exactly a patent is, but nevertheless I would like to start my presentation with what exactly a patent is. Patent is one of the types of intellectual property right which is actually given for a techno-legal invention. So it is a techno-legal document which talks about both the technical and the legal aspects. So when we have an invention per se, we would want to secure it with a kind of intellectual property which is known as a patent. So this is different from other types of intellectual property because it is a negative right. It is given to an invention, and it gives a limited monopoly from the date of filing, which is 20 years from the date of filing. So the first thing is why it is known as a negative right. I have just taken a quote from Steer versus Rogers case. It's a very old landmark case in from the British era, which talks about when letters of patent confer is the right to exclude others from manufacturing. That is what I meant with the negative right, and in particularly a way of using the invention. So that is what we talk about when we are talking about a patent. We are not saying the person who is a rights holder, a patent applicant or an inventor will have a positive right of manufacturing that invention, but he has the right to prevent others from using manufacturing, offering for sale, or any other kind of rights within that particular monopoly which he is given. So next, what I want to say is why it is patent. Why we need to know about patent. The difference in patent and other different types of intellectual property right is, when we are talking about patents, we are talking about something which is on a quid pro quo right. Basically, if you disclose the entire invention, enable in the particular techno-legal document which is known as the patent specification, that is a part of your patent application. After the monopoly ends, this goes completely into the public domain. When it goes into the public domain, the use is whatever information is lying in the patent after its particular monopoly right, it is free to use by the public at large. So that is how patents are used as a tool for incentivization of further research and development. So when we talk about patents, this is the major and one important use which we are trying to seek from patents. So that is the way we incentivize further research and development. I'm sure as a research institute, we have different R&D clusters which are involved in different research projects. So what does one do? Instead of also publishing it, first we would like to secure the right by filing either a provisional specification based on the initial idea, or let's say if we have complete information or details as to how we can perform that invention, we can go for a complete specification. And thereafter, after you file the complete specification or the patent application in the Indian Patent Office or in whichever jurisdiction of choice, we would like to proceed for examination. Once you give that request for examination only, the patent application is taken forward and then it is granted after different to and fro between the patent office and the communication with the patent applicant. So this is in short what exactly happens once you file, once you have an invention, how you harvest it, file a patent application, how you proceed towards the further parts, that is the prosecution, and then you get your right for actually, or the patent right for that particular invention. So what is with respect to patent right, I have already explained. But one needs to understand that what can be patented and what cannot be patented. So if we want to know what can be patented and what cannot be patented, we should know the patent eligible subject matter. So what is the key criteria there? So there are three different criteria which a particular invention must resolve. That is, it should be new, it should have an inventive step, or it should be non-obvious to a person who is skilled in the art, and it should have industrial application. So if it satisfies these important criteria, then it is known as fulfilling the patent eligibility criteria. And what does a product mean? A product can mean, it can be an apparatus, it can be a device, machine, chemical products, drug, food and their composition, chemical composition, biological products. So there are different ways and means and different types. The scope of patent is very wide. Similarly, the scope of non-eligible subject matter also is very wide, because here the key distinction comes between invention versus discovery. Something which is naturally present in the nature is not patent eligible. Something which is a scientific theory, an abstract theory, something which is already known, where there is no human ingenuity involved, it is not patent eligible. So that is why only inventions we are able to secure as an intellectual property right, which is patent. Now, who can file a patent? Now that I have already introduced why we need a patent, what is the patent eligible subject matter, we also need to know who has the right to file a patent. So the patent can be filed by a natural person, by a group of persons, by an institute, by let's say a company, or a large entity or other legal person. So there are different stakeholders or different kinds of applicants who can file a particular patent application. So an inventor. So here the important thing which comes is an inventor. Who is an inventor? An inventor is a person who has actually conceived the idea or of that particular invention, the techno-legal concept behind it, and also understood and carried out the experiments and reduced it to practice. So he qualifies as an inventor. So like in publications, we also have different roles and responsibilities of who can qualify as an inventor, who can qualify as an applicant. So in many cases, it all depends on the legal, the legal relation between the two stakeholders, between the inventor and a patent applicant. So let me talk about the scenario of a research institute like ISM Dhanbad. We have the institute is providing the infrastructure, that is for conducting the research. So in this particular thing, all the research facilities, let's say even giving the kind of environment to pursue that kind of research, giving different ideas, and which is actually the idea hub would be the different researchers, the R&D heads, the experts who are actually carrying out research in different key particular areas. So those people are known as the inventors. But as by virtue of conducting the research in that particular university or the institute, they are actually working for the institute. So basically the inventor will assign their institute to the applicant, which is the applicant, which is in this case, which is ISM Dhanbad. So that means that he is the patent applicant, he is the legal owner, because we are conducting all this research and development by using the government funds, which is public money. So when we are talking about this, that is how we have a clear distinction between an inventor and a patent applicant or an assignee. So in some cases, the patent applicant and assignee will be the same, inventor will be the same. In other words, the inventor will assign his invention in the form of a proof of right to the patent applicant. So these are the people who qualify to file a particular patent application, and they can, with respect to an assignee of an inventor, he can be a natural person, he can be a legal entity with this a company, university, etc. And also a particular assignee who is claiming to be from the true and first inventors, or by any legal representative of any deceased person or assignee. So these are the people who are qualified to file a patent. So once this is clear, what do we need to file? What are the documentations which we require when we need to file a patent? So first thing is we have a covering letter. So this can also be included in the form of a simple letter addressed to the patent office, saying that respected sir, ma'am, the words that we are filing this particular patent application entitled whatever the title is, on this particular date, the following documents have been attached. These are the enclosures. So we have a duly filled in patent application form, which is the form 1. We have a foreign filing form, which is form 3. We have a proof of right, which I am talking about. The inventor will assign his invention to the patent applicant. And then we also have the based on the prescribed fees. Let's say it's a natural person or an individual, a group of persons, or a legal, other than legal entity, or a company or a university which is recognized as an institute of national importance in India. We also have different schedule of which are prescribed in the Patent Act and rules. And then we have after all this particular thing, you need to have something which is talking about in detail regarding the invention. That is basically the form 2. The form 2 can be of two types. You have a provisional specification, you have a complete specification. Provisional specification is for, let's say you have just conceived the idea of a particular invention, but you are not aware like what will be the possible technical effects or what will be the technical advantage or something. You have a rudimentary idea that how it will work, you have a plan of action, the experimental details all designed and all that, but you do not have the entire results in hand. So what in that case what we do, we file something which is known as a provisional application, something which will actually secure the priority date for you to say that you are the first person who has conceived the idea and you are the person who is filing this application. So remember that patent application is not first to invent, it is first to file. That is the distinction here as per the Indian patent law, and most of the jurisdiction follow the first to file concept here. So if you file it first, basically you are actually you have a priority, or you are the first person who has identified, and you claim the legal right to enforce that once it is it goes to a complete specification. Now here, once we talk about a provisional specification, you have 1 year time. That is why it is known as a provisional specification, to identify what are all the experimental details to be done, complete that particular experiments, get the results, and then formulate your clear idea into the technical concept, the technical legal concept, which is actually covered in the claims, which I will be speaking in the further part of my presentation, which actually define the legal needs and bounds of your specification. So it is like a house. When you have a house, you have a boundary wall, and the house will be within the boundary wall. So when we talk about the claims, claims are actually that particular boundary wall which will secure your legal right. So whatever is written in the claim is what you are trying to claim as a technical and legal feature for your particular invention. Then you have a declaration to inventorship. There is a form wherein in which you write who are the inventors of this particular invention, and how their affiliations and all, which is given in the form 5. You have an abstract which is actually something which has the title within 150 words. These are all prescribed in the Indian Patent Act as per the rules and regulations. That is how we need to give. It has to have the title of the invention, of that particular patent application which we are trying to claim. Then it needs to have a concise abstract within 150 words, and if applicable, the figure which talks about a snapshot about that particular invention. So if there are having a figure number is not mandatory. If you have figures in your particular application, you can give it. If you do not have, you can leave that empty. It depends on the type of the invention in question here. So drawings are also, basically it depends on the concept which you are trying to claim. If you need, let's say you are talking about a mechanical invention, or an engineering invention, or a chemical engineering invention, or something which is talking about an article of manufacture or a machine or something like that, then you will have drawings to explain with different perspective views, or let's say flow charts or diagrams. That is covered under drawings. The drawings also need to have a particular format, which I will also be sharing in the future slides. And then the most important thing is a power of authority. A power of authority is required in case the patent applicant is not individually filing or doing the particular formalities in the patent office. So as an applicant, we understand that all the patent applicants will not be aware of the legal repercussions of filing a particular invention. So in that particular case, because as inventors and applicants, we know they are very, very good technical experts in their area. They need not know the legal rules and regulations as per the Indian Patent Act. But when we try to explain it to them, it is not possible that they will be following the rules and regulations. That is why we have some people which are known, who are known as the Indian patent agents, who are registered under the Indian Patent Act to represent the clients legally at the patent office. They will be doing all the filing formalities. They will be drafting the particular invention as per the Indian Patent Act, and actually secure the rights based on the invention disclosure which you are giving in. I'm sure you are following that particular principle here also. You have an invention. Once you have an invention, you have an invention disclosure form which you will be filling with the title and the relevant technical details, which you give it to the DPIIT-IPR chair and the team which will look into the particular inventions, and then they will also draft that particular inventions. They can also take help of other of counsel or other patent attorneys who will do this particular process, and then it is a license process which happens, wherein these people are also involved. They are very, very practically trained to get the inventions in the proper form, in the proper format in which we need to get that particular right for that particular patent applicant. So this Form 26 is applicable only if you are employing a third party, which is a patent agent, to represent you at the Indian Patent Office. If the patent applicant is comfortable in doing all the legal formalities and pursue the examination in the patent office, then he need not file the Form 26, because he is the owner of the particular, or he is the legal entity who is having the rights to pursue the application in the Indian Patent Office. So he need not file the Form 26, but if he is employing somebody else's services, he needs to file this he needs to give the power of authority in favor of the patent agent or agents involved who will do the processes for him, and they will take the decisions on behalf of him so that the right can be secured for the patent applicant. So now I will explain in detail what a patent application is. So it is a techno-legal document, like I have already told. You have a technical part, which is nothing but talking about the technical details, how you have performed the invention, what are all the constituents of the invention, how does the invention occur, or basically what are all the steps taken what are all steps need to be done to get that particular technical result, and which is known under the patent specification. And then you have the claims, which I already explained, which are the legal means and bounds of the invention. And I have also given in a brief snapshot, like what is what the invention will be. Basically, it has a technical part, it has a legal part. It needs to be useful to the public at large after the monopoly, and why it is known as a techno-legal document here. Now, why we need to file a provisional specification, we have already told, when it is just a proof of concept or an idea, and then you need to convert that particular proof of concept to a particular complete invention within a period of 12 months. And why this 12 months is given? Because we need to explore the commercial feasibility, whether it will actually work and all that. So this is actually a kind of a trial case. In case you feel that the results are not as per the ideas which you are expecting, you can always come back, because these provisional specifications are never published. They do not come in the public domain. So you do not have the particular way in that it will come out in the public, it will become prior art or something like that. So it is secure. So that is why this particular route is chosen by most of the people who most of the patent inventors who do not have the complete details, technical details to pursue a complete specification. So it all depends on the strategy which is involved here. Then you have a typical patent application will have 30 pages, including the drawing sheets. And let's say you increase the number of pages, it is chargeable at the rate of 160, 400 and 800. This is all depending on the type of applicant, individual, joint applicants, or let's say a company or a university. So please do not go by the numerics. The numerics will be updated in the Patent Act and the rules as well. You can follow that schedule also. I may be wrong in this particular numerics, but that all will come once you are filing. Once you are finalizing your patent application, you know how many pages your patent application is taking. Then a typical patent application will have 10 claims, which includes independent and dependent claims. And any claim more than 10 is chargeable as per the Indian Patent Act and the rules. So I have already told why we need to file a patent application, because we need to get our fundamental research, we need to improve upon the existing art, we need to resolve the unsolved problems or actually give technical solutions to different technical problems. And what we need to do is find the out of the box technical solutions for existing patent for existing technical problems, so that we can actually fuel more or incentivize more people to enter into that particular research area. So I am explaining in more in detail like how a Form 2 looks. A Form 2 has a cover page which talks about the title of the invention, name, address, nationality of the applicant, and the preamble. The preamble differs from different for provisional and complete specification. The page 2 has these parts, which is the field of invention, background, advantages, summary of invention, working examples, claims, drawings, and abstract, which I have already explained. So the main component of a description is nothing but it needs to be in a clear and intelligent language about the invention, which is talking about the technical details, so that a person who is skilled in the art is able to perform that invention. It should enable people to perform your invention. And what is meant by best mode or enablement? It need not be claimed, but it talks about in a clear and precise language as to what kind of monopoly you are seeking. So it cannot be in an abstract language. You need to clearly define what is the scope of the invention, define the various technical and that is the absolute and the optional technical features involved, and we are trying to not to extend the monopoly, but to limit as per the particular techno-legal details provided. Now I'll talk about the claims, what are its objectives, what are the contents, what are the formats. So this is the most important part of a particular invention, because this defines the legal needs and bounds of the invention. We are talking about the claims. It goes hand in hand with the specification. It should be typically in a single sentence. There are multiple claims. It is usually in a funnel form. The most broadest form is the independent claim, followed by further dependent claims, which are actually more and more adding limitations to the independent claims, and then actually defining the entire scope of the invention. Then you have a preamble, introduction, preface. We need to avoid unnecessary terminologies or phrases which will limit your particular claims, and because they may be used in the court of law to limit the invention. So what are the features of the claim? It should be clearly based on the matter disclosed in the specification. Okay. So when we talk about the claim, a claim is basically read in light of the specification. When we are talking about the specification has the complete legal technical details as to how we need to perform the invention, and once based on the detailed description, you are reading the claims in light of the detailed description, because the detailed description is basically that particular roadmap which will help you to say what is exactly intended in the claims, how you want to secure your invention, and what are you exactly intending to protect. So the principal claim or the independent claim is the standalone claim, which is talking about the novel and the distinctive features of your invention, and the optional features which are not actually necessary for performing that particular invention come under the dependent claims, which are actually adding further limitations to your claims in question. So that is why that is what I mean in terms of a funnel form. You have the broadest claim, which is the independent claim. Then you have the independent claims which are actually adding more and more limitations, and then you try to cover the entire invention. So it can either be let's say an article of manufacture and the method of making that particular article as well. So these are the types of claims which you can think about it. I am only telling two types now, but you can think about different types of claims based on the invention in question. So what needs to be there here? The most important thing is it should comply with section 21J, 3, 4 and 10. So these three sections will these four sections will also come when we are talking about in the first examination report, that is the prosecution. Once we file the patent application, what we need to do, and how the patent office examines or the controller examines your invention once it is filed in the patent office. So 21J is talking about the newness. Then you have 21JA, which is talking about the inventive step, and then you have industrial applicability also, which is covered under the section 2, 21AC. Then you also have section 3 and 4 talks about non-patent eligible subject matter. Section 3 talks about the different subsections from 3A to 3P, which are talking about different categories of inventions which are not eligible to be, or they are exceptions and they are barred to be patented under the Indian patent law. Section 4 talks about inventions related to atomic energy and defense related inventions, which are also subject to secrecy directions, etc. Section 10 talks about the clarity and conciseness of the invention when we are talking about section 10(4) C and all. I know there are many sections, but this is important because you have to clearly and concisely describe the invention well in detail. And I have also told that when we are talking about claims, claims exceeding more than 10 are chargeable per claim. So what is a typical claim? It is a single sentence which is having three different parts. One is the introductory phase, the preamble, the body, and the link which connects the two. The introductory phase is basically trying to talk what is the type of the claim. It can be a device, a method, an apparatus, or let's say it can also be a composition claim, a composition of matter. When we are talking about the simple chemical composition of different, let's say it's a hair oil having different constituents, then it's a composition of matter claim, wherein we are talking about the different components which are used to make the particular hair oil, how they are combined, in what are the ratios, and how in which manner it is produced as well. That is the method of making that particular oil. I'm just giving an example. So, and then we talk about the body of the claim. When we talk, it's after a device, a method, or an apparatus. We are also talking about the specific description by which we are saying. For example, when you are talking a device comprising A, B, C, and then when we are also talking about how it is connected, and then we are connecting those two particular inventions in the particular order, the invention components, and then the linking word is a device comprising of A, B, C, and all that stuff. Yeah, thank you so much. So this is the typical example of a format, a device for making a particular invention, comprising of what are the components, how these components are interchangeably connected, that is the independent claim. A device which is claimed as in claim 1, talking about the subcomponent A. So basically we can talk about the subcomponent A, which is actually having more technical details, and then you refine the technical details which are present in that particular component A. Then similarly you keep on describing the other components, for example in this, and then you say how this device achieves that particular function or the technical result. You have the date and the signature of the applicant or the patent agent who is authorized to represent that particular applicant. This is the typical format of the claims. The format can also include a process of preparation or isolation or recovery of a compound when we are talking about a chemical claim. Then what are all the steps which we are involved, which are involved in this particular isolation or recovery of the chemical compound, how we pursue the steps and how we get the desired product. Then we have the process which is as claimed in claim 1, because this I am taking it as a principal claim, so I am giving further details of the independent claim and the components which are being claimed in the principal claim. Then trying to explain like what each particular compound or the component, subcomponent is doing, and then explaining as to what is the result which is accorded by that particular component. Then a process of preparation of a particular compound as described as per the foregoing examples. This is not usually followed, this is a type, but it is not allowed in Indian Patent Act, because in earlier forms we used to have that. I have just given as an example, but when we look into a more detailed application, I can show you what are all the actual allowed format of claims. I'm not saying this is not allowed, this is not followed now, because we are not trying to refer directly the specification in the claims. The format of the claims to be avoided is: I claim to be the inventor, I claim that the machine is quite new and has not been seen or known before, I claim some reward, I claim this is better and more effectual than anything known, I claim the following advantages. This is a very frivolous way of claiming. A person who has a legal knowledge will not write like this, because you are not trying to claim some advantages. You are trying to claim the advantages which are described in the technical specification or the patent specification, but you will write in the proper language, which is we are trying to claim that particular technical advantage via the technical features of that particular invention. So I cannot stress enough on the importance of well-drafted claims, because what you claim first or what you draft first is actually the boundary which sets like this much only protection legally you are allowed. if you are trying to enhance, there is no way that after you have a piece of, say, for example, I get a 2.5 meter of cloth to stitch a shirt, but then later on I say I don't need a shirt, I need a pant out of it. So definitely you cannot repurpose the cloth which you have bought for a shirt to a pant. That is what I'm trying to explain is you can always reduce the scope of the invention or restrict the claims, but you cannot expand. That is why when you draft, you need to envisage what exactly is that you're trying to claim, what are the different fallback positions. If it is broad enough, whether it will be allowed. Then if it is broad enough, there is another problem here. It will cover all the earlier covered prior arts as well. So you have to exclude the already covered information in the state of art and then only try to cover which is actually something which you have invented or which you have actually given the intellectual efforts that you have done. So you are responsible for fulfilling the requirement of full and definite and succinct disclosure, because if you don't disclose enough, the patent office will refuse your patent application by saying that you have not sufficiently described, so how are you trying to claim this particular technical advantage or legal monopoly over it. Drafted claims, after it is given in when it comes into the public domain, it is not only a piece of document which you will keep outside your table or let's say on your table or let's say on the wall saying that I am the patent applicant or something like that. It needs to stand the test of time in the court of law when somebody fights and says that you do not have the right to get the invention. I am actually saying that you have infringed upon my rights and you legally don't have the right to get this patent. So when you file a particular litigation in the court of law, it needs to be that strong enough a document to withstand the post grant challenges. And sometimes even if in the application stages you are there, somebody can just file a pre-grant opposition in the patent office saying that this particular invention is already known, it is in public domain, or this particular inventor or the patent applicant does not have the right to claim the right on this particular patent application. There are people who keep a watch on what you are doing, especially the competitors in different industries, to see how you are trying to claim your monopoly in which particular area and how one can stop. So that is a very important strategy when you talk about patent application filing and getting the grant. So it is not as a straightforward process as you think, like once we have the application in hand, we'll get the grant and it's done. So it is not such a straightforward process. There are different hurdles, and I'm just explaining the type of hurdles we can face during prosecution. So that is why once you have a proper document only, you can fight forward. So if you, it's like when you're going to the war, you will be having a sword and a shield. So you should know when you will use the sword, when you will use the shield. So that is how is the importance of the patent application or the patent, a well-drafted patent application with the claims, because if you are drafted well enough, then you can use it as a shield to protect that invention or that from attacks from outsiders or the third party inventors or the third party stakeholders. And if you have proper definitions or details given in the particular patent application, you can use it as a sword to prevent others from securing their right on the same type of invention in question. So one thing which you need to remember is anything that is not claimed is disclaimed. So basically it is out in the public domain, and it is so just a minute, I'll just take a tea break in 5 minutes. So after this I just want to tell that whatever is not claimed is disclaimed. So this is with respect to a patent claims when I'll talk in my next session. Thank you. I will continue with the next.
Thank you, ma'am. Tea is arranged for everyone. I request everyone to join for the tea break, and we'll resume the session in 10 minutes. Thank you.